Good morning.
In unison, good morning, Your Honor.
I want to talk about the 400 series exhibits before we start argument on the dismissal. I was trying to review some testimony yesterday. Is someone from the district attorney's office prepared to address that?
Good morning, Your Honor.
Did you work on this at all last night, or?
Well, I'm prepared to address the court's concerns. But I'm not certain exactly what areas you would like me to address.
What I was looking for is independent authentication of some of the documents. The documents were marked primarily by an officer just reporting what he'd seized in a search, and the fact they were seized in a search is not sufficient authentication to get the documents in. So I was trying to keep notes of the various independent authentication as you went through them. And I was looking at the list that I had, and this morning I was trying to go through some testimony from yesterday and the day before, and I found that you had authenticated Exhibit 400, which I didn't admit yesterday. And I suspect you authenticated some others that I missed, so.
Well, in terms of the foundation for the admissibility of all the documents, as we pointed out in our brief, Your Honor, authentication.
I'm beyond your brief.
Okay.
Let me tell you, like on Exhibit 400, we have, maybe it would be best if I address particular problems with you then.
Okay.
I think Exhibit 400 was properly authenticated by Mr. Provencio, Mr. Sanger, rather than have him speak to that, and that's my feeling at this point. Do you have anything you want to address on that document?
I will only because I think that this may have a carryover to some of the others. So let me just say this in general. At the time we filed our brief, of course, Mr. Provencio had not testified. His testimony, I think, is not sufficient for authentication in general. His testimony, besides being highly suspect, was to the effect that he went through a file cabinet that wasn't really necessarily his to go through, and that's where he saw certain documents. He hasn't laid the foundation for what the document is. If we look at 400 in particular, it appears to be, let me move it up here so I can stand at the microphone. It appears to be one page of something that has some purported initials at the bottom. And besides authenticating the document in the sense that, I saw it in this house, that was used by a number of people, including Mark Schaffel, there has to be some authentication as to whether or not this document was actually a document that was effective. In other words, is this a draft? Is this a page of a draft? Is this something that the rest of which was discarded? Or, there was a new first page put on and that's why you have this page. I mean, none of that has been explained. So simply having a page, and having a witness say, that looks like something I saw when I was flipping through my boss's file cabinet.
In other words, he didn't identify the signatures or anything other than to say, yeah, that's a document I saw in their office.
That's correct. And it's only one page of a document. So, we don't have authentication as to signatures. We don't have authentication as to the nature and extent of the document and what it means.
Okay.
Yes.
That sort of, Mr. Sanger was able to sort of pinpoint the problem I'm having with these documents.
Well, our introduction of these documents, the foundation for them, as we pointed out with our citing of the Olgin case, is authentication may be established by circumstantial evidence. We don't need a direct witness to come up and say, I saw Mark Schaffel sign that document, or, I know Mark Schaffel's signature and that's his signature on that document. You look at the totality of all the evidence before the court, and see if you can draw a reasonable inference as to whether or not this document is what it purports to be. Now, we have an abundance of testimony that Mark Schaffel and Michael Jackson were involved in a business enterprise known as Neverland Valley Entertainment, and we found.
I'm not willing to go there with you. The problem is that in your points and authorities, I think you represented that Mr. Provencio would testify that he was familiar with Michael Jackson's signature and initials, and that he would identify them on Exhibit 400, but in trying to review the testimony, I didn't recall that. But
I don't think that was produced.
But going back there, I don't see that in the transcript. So,
if that is a predicate to the admissibility of this document, then that would be one of those foundational minor points that we would recall Mr. Provencio to lay. If that's the place where the court has an issue. And that's why we requested yesterday that we be able to address concerns of the court regarding the admissibility of these documents as we normally would be during trial. We're in an unusual circumstance here, because these documents are being discussed at the very end of our case.
Was there any document that I did not admit out of that series that you think you did authenticate that I just missed the authentication?
Well, in terms of direct testimony, we did provide evidence from the U.S. bank.
Give me an exhibit number when you're talking so I know what you're talking about.
Yes. That would be exhibit number. Let me find it. 418, page 3, the $1 million check. We did ask the U.S. bank representative about that exhibit, as well as
418 and 419 I think was authenticated by the U.S. bank person who testified.
Only as to the pages that are checks. Not as to the other
Documents.
documents.
That's correct. That's correct. 418 to 3 and 419 to 3, page 3.
So I would be willing to admit those pages that she authenticated as those documents, 418 and 419.
And I would submit that, Your Honor.
Okay, I'll admit the checks, and I'll have the clerk separate the other pages and redesignate the other pages as 418A and 419A. The actual 418 and 419 will be the checks themselves.
And that would be the only other documents that we provided direct testimony on.
Well, one of the things, Exhibit 403.
Certainly.
I do not think that you have had Mr. Provencio identify that document and those emails from between Rudy Provencio and Catherine Mylowski. Although on cross, I remember Mr. Mesereau raising some questions about those emails.
There certainly is testimony that Catherine Mylowski was providing substantial information by way of emails to Mark Schaffel.
But I don't think that's sufficient to just dump, then, a bunch of exhibits in if they're not, and I'm asking for argument.
Certainly, yes, as I stated before, you can't deny the circumstantial evidence in this case that we look at these documents, Your Honor, somewhat like you might look at some numbers scribbled on a piece of paper found in a drug dealer's home that are introduced as pay-o sheets. Now, there's no authentication. Nobody comes in and says, that's his handwriting. You don't need that. You don't need to have someone come in and say these are pay-o sheets for a drug transaction. You might have some expert testimony to that effect.
I was going to say, I can't imagine letting that kind of thing in without some authentication, but
I mean, in terms of the admissibility of it, it's not as if there's any.
I think we're going down a side street here.
Our position is that these documents speak for themselves. They are words that are relevant to the conspiracy, and a conspiracy is a crime of words, in addition to some overt acts. And as we pointed out in our brief, each one of these documents impute either knowledge about facts that are relevant to this conspiracy, motive, reasons why these co-conspirators as well as Mr. Jackson would engage in this conspiracy, the relationship between the parties. For instance, phone sheets with virtually every single co-conspirator's name on them. I mean, those are coming in because Mr. Provencio testified to it.
I would really try to direct your attention to one exhibit at a time. It's not helpful to me to be doing that. I lose track of what you're saying.
I understand, Your Honor, there's a number of exhibits.
I think we're talking about exhibit number 403. That's what I want to talk about. So I'm saying, what is the foundation that you've laid for 403 to come in? That's what I'm asking you.
All right, if I could just have a moment, here.
You may.
403. The Fires Brewing file. The court has previously admitted evidence of the panic that was going on among the co-conspirators during this time. There's been extensive testimony by Anne Gabriel that, of a laundry list of problems that confronted Mr. Jackson, public relations problems. The press was going crazy. Not only about the rebuttal, or about the Martin Bashir film, but a number of other issues that came up, including Mr. Schaffel's prior history, the Jordy Chandler release of the complaint over the internet, issues regarding the other problems that Martin Bashir pointed out, such as child abuse or possible child neglect issues. You name it. This is being offered as corroboration of Miss Gabriel's testimony, and as evidence of the issue of the panic, the reasons for that panic that were generated and known by the co-conspirators. Now, it's offered as circumstantial evidence, because these words, these documents, were found in Mr. Schaffel's home, in his files, in his locked closet, and they clearly show a group of files under an unambiguous heading, Fires Brewing, that Mr. Jackson had a number of problems on his hands. And the problems were to be addressed by the co-conspirators. That was the purpose of this.
Let me ask you this. Did Mr. Provencio testify about those documents yesterday or the day before?
He testified that the phones were ringing off the hooks. That there was.
Did he testify about the Fires Brewing documents?
No, he did not.
I think I remember him identifying who Catherine Mylofsky is.
He did identify Catherine Mylofsky as being a conduit through which much of this information came, including, of course, the original script for the Martin Bashir film way before it was introduced, played.
Okay, on 404, it seems there was the phone log and then there was a list of contacts, is that right?
That's correct. This came out of the Stuart Backerman file in Mr. Schaffel's filing cabinet. As Mr. Provencio testified, the media was keeping them very busy. This is a list of messages showing contacts from the media, from Larry King, to Good Morning America, Barbara Walters. And this is on February 6. Again, introduced to show the level of panic that was being inspired by this public relations disaster. Everybody was calling, "Who's that boy that Mr. Jackson is sleeping with?" And it's corroborative of Mr. Provencio's testimony, and it shows.
Was there any specific authentication on that exhibit then, besides the simple seizure of the
In Mr. Schaffel's home? No. Other than, as I mentioned, the reasonable inferences that you can draw from finding it there, in light of all the testimony. And that's what we're asking for, is that the court draw a reasonable inference as to what this document is, what it means.
Okay, on 406.
Would you like to address the working group list that follows that, or?
I'm sorry.
There are a couple of phone sheets in here. Again, this, as the authorities noted, provide that evidence of relationship between the parties is admissible on the issue of whether or not a conspiracy occurred. We have a production working group list that shows Ronald Konitzer, Dieter Weisner, Mr. Backerman, Mr. Legrand, Mark Garrigus on the same working group list in the possession of Mr. Schaffel. Now, Mr. Schaffel cannot contact co-conspirators unless he has contact information, showing that he has their email addresses, their phone numbers, their mobile phone numbers, their addresses as evidence that Mr. Schaffel is working with these individuals. It's evidence of their relationship.
Okay, I understand that.
Okay, moving on to 405?
Yes.
Or 406, I think the court said.
405 was admitted. 406.
406 is the contract for the Fox rebuttal. It's a $3 million contract. There's been quite a bit of testimony about the amount of money that was going to be made in this particular endeavor. This is corroborative of that testimony. It appears to be on a Hale Lane fax transmittal sheet. We had testimony from Mr. Hamid Moslehi about receiving faxes from Hale Lane. This is identical to all of the other fax transmittal sheets that we seized during this warrant. There is no evidence or, I believe, reasonable inference you can draw that this document is anything but what it appears to be, a revised agreement of the Fox Broadcasting Company and Fire Mountain Services. And it's offered to show that this was a money-making enterprise, that Mr. Jackson was going to personally profit from it, as well as the co-conspirators.
You're talking about the
pages 1 through 4.
1 through 4.
Yes. Now, we have introduced testimony that the Arvizo family was to be included in this Fox rebuttal and the reasons why they were never seen in that rebuttal film.
On that document, that's pages 5 through 9, right?
Yes.
And that's
5 through 9 are.
How do we know that Mr. Jackson had anything to do with that document?
Well, Mr. Jackson does not have to be linked to every aspect of the conspiracy.
But you want to admit it to show his involvement in the rebuttal video, right?
We want to admit this document to show that the special was a money-making enterprise, and that, there has been quite a bit of testimony, or there was quite a bit of testimony with Anne Gabriel dealing with the issue of the problems with that, how that would be perceived by the media as negative. She felt it should be done without a profit motive, and how her advice was ignored by the team.
Okay. Exhibit 407?
If I may just remark about the remaining exhibits on 406, Your Honor.
Yes.
Because there were some additional pages there.
Page 10.
And one of the pages is a fax to Michael and Al from Mark, appears to be, with a personal message from Mark Schaffel. It talks about the specifics of the clips, the editing, everything looks good, it's all very positive. Shows Mr. Jackson's direct involvement in the second Fox rebuttal, or Fox film, I should say, as well as, following that, there is the agreement in which the second Fox film was to produce $4 million in income. And we finally have a note from Mr. Jackson signed by Mr. Jackson, care of Al Malnick, that he authorizes giving the keys to Dieter Weisner at the warehouse for Optima Productions. Shows again Mr. Jackson's direct involvement in these films, as well as his relationship to the parties, particularly Dieter Weisner.
Okay.
407 is offered as a statement, as statements in furtherance of the conspiracy.
Well, I'm sorry. Did you want to? That's all right. Okay. 407. Go ahead.
These are emails that were found, I believe. Let me just double check my notes here, in Mark Schaffel's, Ronald, file. And that's how just so you know, you can look at the index and see that we've divided these documents up into the various. We've kept them in the various files that they were found in, so that's the reason why some of the documents do not always have a subject matter relationship, but they do have a relationship of the location in where we found them. This is the Ronald file. There are a couple of emails in here from Ronald Weisner, or Ronald Konitzer, talking to Mark and Stuart. The first one is really just for purposes of showing the relationship of the parties, and their involvement back on February 6, 2003. The second one entitled, Money, February 11, 2003, is highly relevant. It talks about the money split. It talks about how much money they're going to get for the Fox rebuttal. It talks about how they're going to split it up, about how some of it is needed just to pay for that rebuttal. This goes to Mr. Jackson's financial crisis. He doesn't have money to pay for this rebuttal, so he has to generate money just to pay for the expenses. Some of it is going to Hamid. The final page is really where you see the breakout.
Do you think the email addresses need to be authenticated in this?
Well, the email addresses for Mr. Konitzer are mentioned in the other address documents. I mean, assuming that the address documents come in, there's circumstantial evidence that they are accurate, correct emails.
That being the list.
The previous list that we've talked about. These are identical emails that we have throughout and including the emails that are identified in the telephone and contact sheets. There is, and the last page, as I said, is really particularly revealing. It talks about $3,200,000 to be produced from the first rebuttal film. $200,000 goes to Hamid. $1,500,000 to David's trust account to pay bills due now, and that's because of the vendors that are screaming for their money. $600,000 for Mark.
Your Honor, by the way, I'm going to object to just gratuitous remarks for the press. There isn't evidence of vendors screaming for money in this case. Counsel should restrict his remarks to the court's inquiry, which is what is the authentication, and not continue to make gratuitous remarks.
Sustained.
I'm making the sustained?
Yeah, we're really looking at a narrow issue here.
Well, I think, I'll draw your attention to the main thing, is that the $600,000 for Mark, including all production and, vacation, for Gavin.
What about the email address of Mylofsky? How do we know that's her? Do we have someone testifying to her email address?
Well, what reasonable inference do you draw from the fact that Rudy Provencio testified that they received an abundance of emails from this woman?
I thought you just told me that you didn't have that testimony about emails. You had the testimony about the phone calls.
No, he didn't identify the individual email, but he did say he received emails from Catherine Mylofsky, and that Mr. Schaffel and him both received emails from her. So I'm just drawing a reasonable inference that he says they received emails. We look in his file drawer and we find emails. It's not conclusive, but it's pretty close that these would be the emails that he received from Catherine Mylofsky.
Okay. 408?
408 is a printout from a disk. It just is offered to show the financial gain that Mr. Schaffel was obtaining through the marketing of the rebuttal film. Rudy Provencio did talk about foreign rights, so this would be something akin to the previous email, which indicates that Mr. Jackson himself was going to benefit from this, financially from this enterprise, and that there were additional profits out there. Offered on the issue of motive, to show the perception of the parties that this was a valuable enterprise that they could make money on.
How about 412?
Again, I'm sorry, we're jumping ahead to.
Well, 409 has been admitted. 410 has been admitted. 411
is of no great moment.
Right.
That's not important.
So 412 was the one I was concerned about.
412. Anne Gabriel, I believe, did lay foundation on 412. She testified that David Legrand sent her this virtually identical release that was ultimately placed before the Arvizos. He asked her to put Gabriel Media, Inc. on it and then send it back. It finds its way into Mark Schaffel's file in various permutations. One with Gabriel Media, the second without, and then there is a third with MJJ Productions.
Okay, what about 413?
There has been some testimony on 413 that
it was received yesterday.
You received it, Your Honor.
All right, thank you. 415.
414.
Withdrawn. 414 was withdrawn. 415?
These are records that are found regarding the expenses for the rebuttal film. Circumstantial evidence that Mr. Schaffel was in charge of that film. And these records, notably on page 4, have references to the Arvizos. And I draw that conclusion from the cash withdrawals that say, JGSD trip. Janet, I interpret that to mean Janet, Gavin, Starr and Devellin trip. On 225 and 226, there are petty cash withdrawals corroborative of what Mr. Provencio testified to, regarding cash paid out to Vinny. There are cash disbursements on page 6 that include $5,000 to Frank Cassio.
Okay. 417?
And I would just say that on page 17, there is a receipt which.
You know what I'm asking you, though, not what's there, I'm asking you what's the authentication. You're telling me what's there doesn't answer that question, so.
Well, I'm just telling you about areas of testimony that are relevant to. That Rudy Provencio did testify about a cash receipt that was signed by Vinny Amen, and that is in that file under page 17.
But he didn't identify that.
He didn't identify it, no.
You're saying that's the one that he must have been talking about, right?
Yeah. I'm drawing a reasonable inference from the location of that document in the files.
Okay.
This is, 417 is the documents. The first document entitled, Janet Strategies, located in Mr. Schaffel's files clearly provides some circumstantial evidence of an intent to come up with various strategies to deal with Janet Arvizo and her family. You can read the document. The same thing with the, quote, David case. The strategies are not always consistent, and they're admitted for purposes to show consciousness of guilt and knowledge of the criminal purpose of this conspiracy.
To show whose consciousness of guilt?
The co-conspirators.
Okay. 418?
You admitted that this morning.
That's already done. 419 is done. 420?
418, we've already.
No, we did 418 and 419, I'm sorry. 420 is where we are.
420 are the emails amongst the co-conspirators, including Mr. Schaffel. Some of these specifically reference the Arvizo family. They certainly reference the panic that existed at the time.
Were the email addresses authenticated, identified, and how do we know who they came from?
The email addresses are, well, I would submit that if we have an email that is from melanie@belliard.com, and we have testimony that Belliard is the crisis management team in London that was dealing with Mr. Schaffel at this time and he's one of the parties on the team, that is circumstantially sufficient foundation that this email is what it purports to be. There's no evidence that these are all fabricated. To the contrary, that these are all seized in a search warrant. So these came out of files the personal files of Mr. Schaffel. So I guess, I keep drawing the same these are my inferences. They may not be yours, Your Honor, but that's where we're going with these.
On 421, that's a contract after the alleged events. Is that?
It is.
What would the relevance of that be?
The defense has announced, and maybe, well, I shouldn't say that they've just announced it. They have attempted, through the introduction of evidence through cross-examination, to show that Mr. Jackson was an unknowing party to this conspiracy. They, in some respects, seem to concede there was something nefarious going on, but not involving Mr. Jackson. If that is the case, then the continued association with the co-conspirators beyond the conspiracy, even after all of the fallout, would tend to rebut that claim. And we have, this is just one link in the many links we have, that Mr. Jackson maintained his affiliation with Mr. Schaffel, Mr. Weisner, Mr. Konitzer, for months and months and months past the conspiracy. So this was not a situation where some bad things happened and Mr. Jackson then fired everybody. It also shows the financial motive of the various co-conspirators to continue in their relationship with Mr. Jackson. This is all about money. We don't dispute that among the co-conspirators. They're interested in a financial gain. But the financial gain they are seeking is from the success of Mr. Jackson, not from his fall.
Okay. 422.
There was testimony about these documents. Mr. Provencio did look at them. He did identify them as the operative documents that established the loan with royalty advance funding that bankrolled Neverland Valley Entertainment.
All right. Thank you. Mr. Sanger, do you wish to address any of these?
Yes. Thank you. I know we have other things to do, so let me try to go through as quickly as I can. I think I addressed 400.
You did.
Okay. That takes us to
403.
403. One quick correction, and I think it really helps to illustrate how little foundation there is for this. Your Honor had indicated that you believed that Mr. Mesereau had referred to perhaps something in that exhibit or related to that exhibit. If I'm not mistaken, Mr. Mesereau is referring to something totally different. He was referring to an instant message communication, which, although there's advertisements for instant messages at the bottom of some of those purported emails, they are not instant messages. The instant message is a real-time exchange where one person types something and the next person responds, and they go on in, more or less, real time. And it was not, as far as I know, and I've looked through it again quickly, it was not one of the documents in the 400 series that had been marked by the prosecution. So there's been no authentication, and this will apply to all these other emails, so I don't have to repeat it.
All right.
No authentication. We don't know who sent the emails, if they were received by somebody in particular, if they were reviewed by somebody in particular, if they were possessed, if anybody had knowledge of it. Most importantly, it has nothing to do with Mr. Jackson's knowledge of anything. There's no indication from Mr. Provencio's testimony or anybody else that Mr. Jackson had knowledge of any of this stuff that's in here. And I'll say that generically so I don't have to repeat it. There's a way to lay a foundation in a court of law, and it just wasn't done. I don't know if it could be done. I take it, because they didn't do it, they didn't have a witness who could do it. But whether they could or they couldn't, it was not done, and therefore none of these things are admissible. I'll go to 404. Again, no specific authentication. The indication is 404 had something to do with Stuart Backerman. And the question is, what did it have to do with Stuart Backerman, just like all these other documents? Quite frankly, I've forgotten exactly if it was in a Stuart Backerman file or whatever it was. We now have testimony that there were several people who were in that house, using that house as an office, several people maintaining desks and having phones, having files. How do we know who had what? The people cannot. The prosecution can't get up here and say to the court, everything is some kind of statement that is in furtherance of the conspiracy, or it shows the state of mind of a co-conspirator, or some other thing like that, and not identify which, if any, co-conspirator it relates to. They haven't alleged that Stuart Backerman was a co-conspirator. They haven't alleged that Belliard was a Belliard is a reputable public relations firm in England. And the testimony is that they were a public relations firm. I mean, he can't say everybody that helps a celebrity with regard to productions of, or people associated with a celebrity, with a production of an event or a video or a television show, is involved in some kind of a conspiracy, and therefore, even though there's been no proof as to who possessed it or what it must belong to some nebulous co-conspirator in some giant conspiracy. And that, again, is an underlying problem with some of the subsequent ones, so I'll spend just a moment on that at this point. In other words, the proper way to prove something is to prove that it was in the possession of and belonged to a particular person, that it was sent by somebody in particular, that it had some significance. It isn't just a piece of paper there. You have to authenticate it. Just the fact there's a piece of paper there doesn't cut it. The analogy for a pay-o sheet I think was actually telling. Because if you have somebody who is caught, with the dope in their room and under their bed, and under the bed with the dope is a sheet that says so and so, somebody something, you still have to authenticate it. Now, it may not be an issue as to wrote it. If it's an issue as to who wrote it, and whether or not the person who's charged had knowledge and possession of that pay-o sheet, then it would be a big issue. That's the issue that we're dealing with here. It's an issue as to what Mr. Jackson knew, if anything, about this. This is a lot of junk that was taken out of somebody's house and thrown in with rhetoric that it's highly relevant. Highly relevant is what the district attorney wants to make out of it. But that isn't the authentication. And that's where they're stuck and they haven't laid the foundation. 406, the first 4 pages are not authenticated as to signatures or significance or who it came from or what happened. It's just a document that's there. The next pages, 5 to 9, are pages that, once again, we don't know what it is. It's not signed. There's some notes by somebody, the handwriting hasn't been authenticated. Who possessed it, who had knowledge of it hasn't been authenticated. It, again, doesn't link Michael Jackson to anything, because there's absolutely no evidence Michael Jackson had anything to do with it. Now, I'd remind the court respectfully that the witness that did testify, the police officer that testified to the seizures I believe is Detective Bonner, said that he wasn't sure which pages were attached to which pages. He didn't know who wrote the numbers at the top until he took a break and was informed they were DA numbers. And in fact, he said that, at least as to a couple of the exhibits, it was questionable as to whether the items that were stapled together actually went together. So we have a problem that the jury would be given a bunch of documents that are stapled together or put in a binder by the district attorney that are given significance the district attorney wants to give them, but there's no authentication that they belong together or have anything to do with each other or were actually known of or possessed by anybody. Page 10 of that exhibit, the words of Mr. Auchincloss were, "It appears to be a fax." That is exactly the problem, is that it appears to be a fax. We don't know what it is. And then page 11, I don't want to get ahead of myself here, is another document that, if I'm in the right place, is another document that's unsigned. And the very last page was offered as a letter purportedly signed by Michael Jackson. And a lot of discussion was had by the district attorney about how significant this is, that this shows Michael Jackson had a connection with Dieter Weisner. It's offered for the truth of the matter. You can't offer a document for the truth of the matter. And you can't say this is signed by Michael Jackson just because it's found in somebody else's house or office. You have to lay a foundation. You have to establish authentication. And that's all. It wasn't done. That's all there is to it. Go to 407, again, those documents are subject to all the same criticisms. I heard Mr. Auchincloss say they were accurate and correct emails. Well, that would be nice if there was evidence that they were accurate and correct emails. The fact that he says accurate and correct doesn't make them accurate and correct. It doesn't make them emails, it doesn't make them anything. No foundation was laid. Go to 409.
No, that was admitted. 410 was admitted.
Let me.
You need to go to 412.
Did I talk about 408? I think 408 was, I wrote 409. I meant 408. I'm sorry. 408, was that withdrawn or?
408 would be your next.
Alright, I misspoke when I said 409. 408, this was a document that we were told came off of a disk, and then as I recall, the officer said that he printed out or somebody printed out what was on the disk. We have no idea who inputted this information into the disk, who had knowledge of this. There were quite a number of people at that house. The fact is it doesn't mean anything. And the prosecution wants to use it to imply that somehow Michael Jackson had some interest in the data on this disk. And there's absolutely no connection whatsoever with regard to that. If we go to 412, there was reference to Anne Gabriel. Her name is actually Anne Kite. And once again, these are documents that are found, they're subject to all the same objections that I've already made. Same with 413. In fact, if you put 412 and 413 together, they're for the most part blank documents that are not signed. There's some other things in there, some handwriting. We don't know whose handwriting it is. This is not the way you present documents to the court.
I did admit 413 already.
I'm sorry. Okay. Well, and evidently, I'm sorry. This a good example of how you present documents to the court. Laughter. Okay.
415.
Go to 415. Interesting. 415. This is a collection of documents that I suppose there could have been some foundation laid for it. All we have is that they were seized. The prosecution is adamant about wanting to introduce 415, and they do not want to introduce 416, which is a summary of petty cash expenditures for Janet and the children, and is exactly the same except evidently they feel that it doesn't make their point. We have the same objections to authentication on 415 that we have on the other matters. But if the people were going to successfully offer 415, then upon that, the court's ruling in that regard, we would then offer 416. If that's an adequate foundation, I think the same foundation was laid for both, whatever it is. And I did specifically ask the officer about some questions about 417. So whatever authentication he was able to give, he gave at least as much as was given by the people for the other document. 420? Actually, the correct discussion I think would be with regard to 420A, if I'm not mistaken. 420 were the documents that were originally presented in the notebook, and then I believe the prosecution gave us a new set of documents which were marked 420A. Is that consistent with the clerk or the court's recollection?
I'll look at my.
While the court's looking, I think that the idea was that Detective Bonner, I believe, testified that 420A was a better set.
You're correct.
So I assume that actually 420 was being withdrawn by the prosecution, and I would assume that their remarks pertain to 420A, not 420. May I assume that?
I think so.
Okay, thank you. So I'll respond to 420A. The offer was these are emails amongst co-conspirators. Once again, that's relevance, but it doesn't establish the authentication as to the email addresses, where they came from, how they got in the file, who saw them, and so on. 421. I believe this is the particular document, Exhibit 421, that Detective Bonner said that he couldn't be sure that the first page went with the other pages. In fact, as he looked at it, it probably didn't. And I think if you look at the content, Your Honor will see that the cover page doesn't seem to match the dates of the subsequent document, nor does the cover page have a fax header. So it looks like somebody stapled a different fax sheet to two other documents, and that just plain highlights the problem that we have with these documents. And that's what happens when you don't have authentication and the court's asked to just assume that if it's there, it's all okay. Once again, there's a purported signature of Michael Jackson at the end of that, the very last page of that document. There are no other signatures. We don't know if this was a draft or a proposal. We don't have any authentication of his signature, that is his signature. And I think, as we pointed out in our moving papers, if you look at the various signatures that the prosecution is offering as Mr. Jackson's signatures in this series from 400 to 423, Your Honor will see that there are remarkable differences between some of them. Some of them are similar. But there are others that look totally different. And not that we're asking the court to do a handwriting analysis, but that's just an example of why authentication is necessary. You can't just assume, based on the fact it's found in somebody's house, that Michael Jackson signed it. Particularly if it's found in the house of Mark Schaffel, of whom the prosecution witnesses have said some pretty harsh things about his integrity. So we have documents that are going to be held against my client in a criminal case that are in the possession of somebody who's been accused of being a liar and not a reliable person. And the signatures don't look the same, and yet the jury is going to be asked to assume that Mr. Jackson signed them all. That's exactly why you need authentication. And we don't have it here. And that takes us to 422, am I right?
Yeah.
422. And 422 is suffers from the same problem. The only difference is that Rudy Provencio actually did look at these documents when he was on the stand, and said that he believed those were the documents pertaining to this transaction. How did he know that? He was apparently snooping in the file cabinet. He had no direct involvement in preparing these, dealing with these or anything else. And as the court I think gathered, and more about that in a minute, Mr. Provencio was trying to be a very helpful witness to the prosecution and lied about things that we can conclusively show he lied about. So his testimony should be disregarded. But if it's not disregarded entirely, at least there's something there. However, it does suffer from all of the other problems the other exhibits have. And I'll submit it.
All right, thank you. Who's going to argue the motion to dismiss?
Mr. Sanger is, Your Honor.
May I offer one more thought on that last one?
Yes.
I mean, one thing we could do is to offer defendant's 977 waiver as evidence of his handwriting. Ask the court to take judicial notice of that.
Okay.
All right.
What I'm going to do? I'm going to listen to the motion to dismiss. I have a pretty good idea now, having heard your arguments on the other exhibits. I've made notes to myself as to their admissibility or non-admissibility. I'm not going to announce those now because we need to move along.
Yes, sir.
But I wanted to take care of that before you argued the motion to dismiss so that I would know in my own mind what documents I would be considering, if any were alluded to in the motion.
Very well.
So you may go ahead. Mr. Sanger?
All right, we did have that Doyle motion, which is just, I thought, Your Honor.
The court will deny the motion for a mistrial and deny the request for specific instructions. Basically, I think that Mr. Mesereau, on his cross-examination, adequately covered the area. And I'm going to leave it with that. If you want to submit, as in other cases, a special instruction in the final jury instructions, I would consider it at that time.
Okay, thank you, Your Honor. All right, with regard to the motion for judgment of acquittal based on insufficient evidence, that was coupled with a motion to strike statements allegedly made by the co-conspirators. Let me argue the main motion first, because I think that would be a consequence of the court's ruling, although the court could independently rule to strike the co-conspirators' statements or it could do it first or second, I suppose is what I'm saying. So let me address the motion for judgment of acquittal. There are 4 areas of the prosecution's case that I want to address, and I want to address them in the context of the law that we have already briefed under 1118.1 of the Penal Code, and briefly indicate that law includes the court's determination that the evidence is reasonable, credible, and of solid value from which a reasonable trier of fact could find the defendant guilty beyond a reasonable doubt.
Let me ask you. I read your motion, which you really seem to be asking me to make some credibility calls on the witnesses. And isn't it true that that's not my job? I mean, that is exactly what I shouldn't be doing, is be the person who makes credibility calls on the witnesses.
No, I think that is that's why we cited that.
You cited a general jury instruction, so.
We cited the case specifically of People v. Allen, 2001 case, which cited, that's a Court of Appeal case, which cited People v. Stanley, 1995 California Supreme Court case. It all goes back to Jackson v. Virginia, which has nothing to do with Mr. Jackson, my client. Jackson v. Virginia was the United States Supreme Court decision in which the U.S. Supreme Court talked about the standard of review and whether or not a rational trier of fact could find a defendant guilty beyond a reasonable doubt. That Jackson v. Virginia instruction has been used for the purpose of sufficiency of evidentiary view by appellate courts, and it's been incorporated into the California standard for the review of an 1118.1 motion for the review of the evidence under that code section. And as these cases say, the California Supreme Court has said that the court has to look to see that the evidence is reasonable, credible, and of solid value. In other words, the mere fact that somebody threw something up on the wall and it wasn't ruled inadmissible does not mean that the court has to defer to it. So this is, in fact, different than the kinds of rulings the court was being asked to make, for instance, on 352 evidence, and some other places where the court was saying, well, I'm not supposed to weigh the credibility, or 1108 I'm not supposed to weigh the credibility. We've had those discussions. The court, we argue, well, you should anyway, but the court took that position. However, with regard to 1118.1 motions, the court does consider credibility. Now, it doesn't mean that Your Honor sits there and says, I am going to pretend I'm a juror and I'm going to decide this case based on how I would vote if I were a juror. But it does mean that this is now the one place where the court can say the prosecution has put on all their evidence, they've rested, they took their best shot, this is it, and a rational trier of fact could not find the defendant guilty beyond a reasonable doubt. The emphasis on rational in the case law, all the way back to the U.S. Supreme Court decision in Jackson v. Virginia, is extremely important. It's not just words. It's based on the idea that the court, as a jurist, a lawyer who's become a judge and has sat and heard cases, in this court's case for a long time, a jurist.
I resent that. Laughter.
Or you started early in life or something. The point of the story is that a jurist, of course, is supposed to be able to look at things dispassionately, and we are supposed to be able to avoid submitting matters to the jury, where a jury, a rational trier of fact, cannot find the defendant guilty beyond a reasonable doubt. So it is a much higher standard. This is not the 995 standard either, where the court just determines whether or not there's probable cause or a strong suspicion that a crime was committed, that being the standard for 995. This, under 1118.1, is rational trier of fact could not find the defendant guilty beyond a reasonable doubt. So the court does have a considerable burden to look at the evidence and determine whether or not a rational trier of fact could look at what just happened here over the last 10 weeks, or whatever it's been, and find a defendant guilty beyond a reasonable doubt. So there are 4 areas I'd like to talk about as far as the evidence is concerned. And I'll try to go through as quickly as I can, but this is important, so I do want to cover it.
I don't want you to feel compelled, because of a deadline, to hurry. Because I needed that extra time on those 400 exhibits. So,
Sure.
we're going to take our regular break and then I'm going to tell the jury that it's going to be a while, and give you time to argue this. I didn't mean to reduce either side's time for this important motion.
Very well, thank you.